Ravi
Okay.
Chandranji has some question in case we can
Thank
take.
you. Good, good morning, sir.
Good morning.
Sir, the proposed amendment in 526 is only for non-core assets or core assets also, sir?
No, any kind of asset. I just wanted to give you a kind of use of this amendment, that in many cases there are some non-core asset and that can be proposed. The resolution applicant can propose in the resolution plan that I will sell these assets, and that actually will you will be used for either payment to the creditors, or he can make the payment before. But then there is a also kind of interpretation difficulty in the over IBC, that whether the resolution applicant can sell the assets or not. So this also clarifies that resolution applicant, even before the payment or after the payment, can sell the assets. So whether he is using this proceeds of these assets for making payment to creditors or not, that will depend upon the commercial wisdom of the committee of creditors. But a resolution applicant can sell the assets. That is also clarified.
But if he sells, will it not clash with the the liquidation process itself?
No, it is not a liquidation process.
Since the COC is already approving the resolution plan, COC is believing that yes, selling the assets as part of the resolution plan will maybe give them a better or a faster result. So I think that is something that they have kind of clarified, because I think this is again to clarify some judgments which say that the resolution plan cannot strip the company of assets. So this takes care of that thought process, that no, that is also allowed. Resolution plan can be anything.
Okay, thank you. Yeah.
Namashtami. And coming back to our passion, which is reading, researching, and then sharing with our participants. This amendment bill, IBC Amendment Bill 2025, introduced in Lok Sabha on 12th of August 2025. And on 13th of August, it was referred to a parliamentary standing committee, a parliamentary committee rather, not standing committee, and probably it will be now discussed and passed in the winter session after some amendments, if anything, which is recommended by the committee. But we need to understand what the intent of lawmakers and how after this amendment bill is passed, after this becomes an act, how would it influence the implementation of insolvency and bankruptcy code in India? The rationale behind this bill is the experience of last 8 years, various judgments from Supreme Court and NCLAT, various disputed issues which are now proposed to be rest at last, and the parliament will now direct that this is what is our intent. So accordingly, the courts will not give kind of judgments which are controversial or which are kind of not on the same parity. Interest shall exist only if it creates a right, title, or interest or a claim to a property pursuant to an agreement or arrangement by the act of two or more parties, and shall be merely by operations of law for the time being enforced. No, one very important condition that has been brought into the security interest definition, and that condition is that the security interest, the lien, the mortgage, the charge has to be created by the act of two persons or more parties by way of an agreement and arrangement in writing, and shall not include security interest created merely by operations of any law for the time being in force. Very important. The clarification of security interest, this basically it must arise from an agreement arrangement between two or more parties that creates a right, title, or interest. So that means it also says the exclusion of operations of law. the security interest shall not include those created merely by operations of law for the timing in force. This means, for instance, a provision in central or state legislature or a subordinate law stating that a charge will be made on the CD's property for non-payment of tax or penalty will not be considered a security interest under this definition. So the validation of an agreement-based security interest, it validates only agreement-based security interest. And for example, charge created over the CD's property to secure financial debt under an agreement or a mortgage created by depositing title deeds, that is what was now validating the security interest. Now, let us understand what exactly influenced this amendment. And this, in fact, it was influenced by State Tax Officer versus Rainbow Paper. This was the judgment of 2022 from Honorable Supreme Court. In this judgment, court held that the statutory provisions under the Gujarat Value Added Tax Act 2003 creating a first charge on the debtor's property for unpaid taxes qualified the government as a secured creditor under the IBC. This was a judgment which was, of course, a controversial judgment in 2022, and the entire IBC, in fact, struggled after that. This elevated government dues in priority during liquidation or during CIRP disrupted the IBC's creditors hierarchy. The amendment explicitly exclude such law-operated charges from the definition of security interest, effectively overturning this holding, overturning this judgment, and restoring the original intent of Section 53, where government dues rank below secured financial creditors and workmen. So the impact of Rainbow Paper Limited, State Tax Officer versus Rainbow Paper Mill is actually now overturned in case this bill becomes act. Secondly, one very kind of judgment which comes from Supreme Court affecting most of the real estate cases. Greater Noida Industrial Development Authority versus Prabhjeet Singh Soni. This was from Supreme Court in 2024. In this case, the Supreme Court, in fact, classified development authorities like GNIDA, Greater Noida Industrial Development Authority, as secured operational creditors due to statutory provisions under the Uttar Pradesh Industrial Area Development Act 1976, which deemed unpaid land premiums and dues as created a charge or security interest over the allotted property. This judgment extended the Rainbow Paper rationale to non-tax statutory dues. Post-amendment, such interests created merely by statute without party consent would no longer qualify as security interest, rendering this classification invalid. Now, two judgments. And now, in case we see, I'm okay with the State Tax Officer versus Rainbow Paper Limited. Very important that the impact of that judgment will be completely overturned. But in case we say that all these land development authorities, they would not have the charge over their asset by way of implication of law, that means they would not be considered as operational creditors. Now, when we see, when our team studied all this, our team have seen that this Noida, even UPSIDC, UPSIDA, even Maharashtra Industrial Development Corporation, even Karnataka Industrial Area Development Board, even Indore Development Authority, they all has clauses in their allotment letter that allotment can be cancelled after notices for non-payment of dues as per their lease deed and policies. Similar, Greater Noida. So the cancellation of allotment, cancellation of lease is automatic or initiated upon default. lease can be terminated for non-payment of lease premiums. Allotment letters include clauses for cancellation and land resumption. Cancellation provisions exist. Now, even if we see this housing boards and urban development authorities like DDA, Haryana Housing Board, Chandigarh Housing Board, Odisha State Housing Board, Rajasthan Housing Board, Tamil Nadu Housing Board, Greater Mohali Area Development Authority, even other entities like state-specific urban development authorities like HUDA or HSV. So when we talk about all these authorities who actually develop land, develop industrial areas, develop business areas, and then they allot the land on freehold basis or on leasehold basis, they have clauses that in case of their dues, they have the right to cancel. They have the right to cancel the allotment. No, for cancellation, nobody can stop them from cancellation. And in case they cancel, the project would not be completed. In case they cancel, that means that the further sale purchase transaction would not be possible. So therefore, what I'm trying to say is that this particular part is still not resolved. This particular part is still not resolved, that if they have a right to cancel the allotment or the lease, then where do we stand? That part is not yet resolved. What is resolved? That this, by implication of law, since it is mentioned in their act that against the unpaid lease premium or other dues, they will have lien on the property, that is resolved. But the cancellation is not resolved. So they will cancel it. They will not allow any further development. They will not allow change of owner. They will not allow further approval of the various requirements for even continuing construction or restart construction. So therefore, this part is not yet resolved. So what we assume, and then we have seen also at Noida, Greater Noida, the authority will take 100% of their dues. Authorities will take 100% of their dues, and they will not suffer as the other creditors are suffering, because they have the power. What power? That they can cancel. They cannot allow you to continue the construction. They cannot allow you to continue the use. They cannot allow you change of transfer ownership. They see they can hold on to anything. So ultimately, it will be assumed that they will have to be paid full amount, whatever is due to them. And this is what is our analysis. Would you like to add anything, or I shift to the very next amendment? See, in the very first amendment,
the amendment is carried out by a basic, elementary level change in the definitions. Then it is difficult for the government to have it, done retrospectively. So that I think we can check, because many a times the government would introduce an explanation or a proviso to clarify an issue. And if they do that, then it is understood to be applicable even to the law which was in place earlier.
Yes, I believe. Yes, you're right. Absolutely right. I think
that
explanation would actually mean that this was the original intent of the government. So now they have even added an explanation to make it more clearer.
So this is an explanation, right? They've added an explanation.
This is an explanation, and this is inserted. So when we add explanation, that can be always considered that it was originally
that is normally understood in law, that an explanation, when it is added, and courts normally say that yes, this is what this section was supposed to be read as, and the explanation then gives a retrospective effect to the entire scenario. So I think then that would also then have retrospective applicability on all the ongoing cases to resolve these two issues. And secondly, I would like to add that this whole idea that what should be the course of action for development corporations or for Noida, like Greater Noida Industrial Development Association, so authority. So these, I think, are operational issues which IBC chooses not to go into, because, like in case somebody allots a land to someone else, that second party, and So IBC is not supposed to decide on the detailed process on what can be done by that person to revoke that land allotment in case they don't pay. All those things are more commercial in nature. It will be up to these authorities now to understand that is this is our status in IBC, and what do we want to do to kind of take care of third party rights uh, that are developed in the land which we sold to somebody on credit basis. So I think that is important to be kind of taken care of by these industrial development authorities.
I think Ankit, Mr. Shantanu, our partner in Mumbai, he actually would like to say or would like to ask some question. Can you just
So, so I can even ask, I can just read out what he's saying. So, Santanuji says that it is written later in the Amendment Act that if there are some rights which are continuing under a contract, the same shall not be terminated during CRP and the remainder of the lease term. However, the resolution applicant will have to fulfill the conditions from the date of approval of the plan. So, yeah, I think that's also the essence that we have so far.
No, I think that is, I have not found that word lease or allotment in that section 14. We will come to that, Ankit, and I have not seen the word lease. I have seen various other words, but the lease or allotment have not been seen in that section 14 amendment. I think where Mr. Shantanu is
So
trying
talking
to
about an
say that.
example where I am like we are taking care of that case in AAA. So we have a land allotment in a company and the land allotment stands cancelled prior to CRP date. Now today the company would have the rights that it has to restore that allotment or cancel revoke that cancellation. I can't today use IBC to say that no, I need a better status as compared to what it was prior to CRP initiation. So I
Absolutely.
believe those are
So
different
this,
issues that need to be
I
taken.
think moratorium, we hope that we'll be able to cover today.
Yeah,
But yes, I think in case Mr. Shantanu would like to say something, he can. But then what he is trying to say, I have not found the word lease or allotment in those words.
I think
I
we
think
can
in
come
the
to that
meantime, while
part.
he's checking,
I,
we can actually we can do the couple of other
yeah,
clauses. And
yes,
then we can see in case he still feels that.
we can move to the next one.
Yes. So the next amendment is the section 3, subsection 31. Again, we are at definitions only, and this definition is like there is an insertion, which is the section 3, subsection 31, capital A is being inserted, which is providing a definition of service providers. Although we are service providers as an insolvency professional entity, information utility, insolvency professional agency, we are all service providers under IBC, and we are registered with IBBI. But now the IBBI is like trying, and that any see they're trying to add like that the service provider means an insolvency professional agency information utility registered with the board. Like they have not even still covered insolvency professional entities registered with the board, and any person falling within the category of person notified by the central government for rendering services in relation to insolvency and bankruptcy processes under the code and is registered with the board. Now, one conspicuous like we can found is the insolvency professional entity is not added in the service providers list. Secondly, what kind of further category that they would be introducing? Is there any intent that the IPE would be removed and a new class of service provider would be added that can be a process consultant or maybe or a support services? But the IPE is a support service, but like kindly see, IPE is not added as a service provider, whereas most of the regulations, in fact, also regulate IPE. So IPE is not covered here. So we definitely, Ankit, we would like to send an email that what is this intentional or it has been just skipped, and also what kind of Ajanta has raised hand. Ankit, in case we can take Ajanta.
I don't see a raised hand.
Okay. Okay. So this purpose, the purpose of this particular amendment seems to be that the central government actually to notify additional categories of persons whose services are required for the implementation of the code,
Yes.
thereby empowering the board to regulate them for a different and proper conduct of the insolvency. So this is this basically one, notifying the service providers must register with the IBPI. Post-registration, they must adhere to the IBPI specification on service standards, empowers IBPI to regulate a broader ecosystem of service providers, ensuring accountability and uniform standards. As I said, that they may also register forensic auditors or transactional auditors. That's what I believe. Enable central government to dynamically notify new categories, like, for example, valuation, of course, is already there. And then, like, coming forward to section 5, section 5.
Mr. Anil Goel, can I chip in for the 1 minute?
Yes, yes, please. Yes, please.
So good morning, sir. Thank you
Good
for
morning.
allowing me to talk. Regarding IPE, since IPE is not mentioned in the code, right? So it is not there. And further, we have added it, anyone just register, but that is notified by the central government, that relates to register valuer and registered with the IPE, IBBI, that will be IPE. So all will be covered gradually, sir, right?
Okay, all will be covered gradually. But
Because
since we were changing the service provider's definition and we were inserting this definition, the IPE could have been added from the parliament itself, probably.
IPE is not actually there in the entire code right now, no? So that's have been left. But IPE as IP is covered still, Hana?
Yes, IPEs are covered, but the IPE is not covered.
Right, sir. Right.
IPE also can be covered because see, since this was not this was a creation of regulations.
Yeah.
So that can still be done. Yes, Ajanta.
Done. Thank you.
Thank you. So I think Ankit, Venkata Rao also would like to say something. Should you allow him?
Yeah, I've done that.
Yes, sir. Thank you for giving me the opportunity. Sir,
Yes,
presently, when we see where service providers are defined, IBBI inspection regulations define who are all the service providers. There, even registered valuers were added, whereas in this definition, in this amendment, registered valuers are missing. If you verify IBBI inspection regulations, there, who are service providers has been defined.
So registered valuers, again, I think the point is the same, that the idea is to add those professionals here who are mentioned in the code. Registered valuers, I believe, are also not mentioned in the code. They are only part of the regulations. That is the common idea behind which professionals have been stated particularly here and which professionals will be notified through a central government notification.
Sir, ultimately, some of the amendments appear to me that they're harmonizing regulations and IBC provisions. In such an event, when they are already mentioned in the inspection regulations, so in the present amendment should also cover that, is my view.
I think it's more of a legal issue that in a code, in case certain professionals are mentioned, only those professionals can appear in the regulatory provision with respect to regulation of those provisions. The rest, I think, they would want to cover through the alternative process of notification.
Yes, Ankit. I think we can move on to the next amendment, which is amendment to section 5. And in fact, the renumbering has been done. Section 2, the subsection 2A deals with the base resolution plan, means the resolution plan provided by the corporate director under clause C of subsection 4. And then of section 54 is proposed to be renumbered as 5. So this means a transaction as referred to in 43, 45, 49, 50. This insertion. Now, this insertion, the avoidance transaction actually has been added. The section 5 subsection 2 capital A. It introduces a statutory definition of transactions under section 43, which is preferential transactions. Section 45, which is undervalued transactions. Section 49, defrauding creditors and for related to undervaluation. And section 50 is extortionate credit. So these are the transactions, and now the intent is to differentiate between the transactions and fraudulent trading and fraudulent transactions. This actually enhances the clarity and consistency across the code, aiding resolution professionals and the adjudicating authorities in categorizing such suspected transactions. And then again, in fact, the section 9 capital A is inserted in section 5 in the definition part of it, where the fraudulent or wrongful trading means a fraudulent or wrongful trading as referred to in section 66. The impact of this is again it has been codified, because since the most of the judgments which has come, those judgments, especially the Piramal judgment, they actually have said very clearly that as far as this adjudication of transactions is different, and adjudication of fraudulent and wrongful trading is different. So, in fact, the court in Piramal have said, I will come to that immediately after this, but it reinforces the personal liability for misconduct, deterring, and see. Now that we will come later, how this fraudulent transactions and the transactions and the fraudulent trading separately would be in fact good, and it is based on the Piramal judgment. Then coming to the section 5 subsection 11 amendment. Now the existing definition, it actually is very, very important. Existing definition, it says section 511 says, talks about the initiation date. Initiation means CIRP initiation. The date on which a financial creditor, a corporate applicant, or operational creditor, as the case may be, makes an application to adjudicating authority for initiating corporate insolvency resolution process or prepackaged, as the case may be. That is a initiation date, and it is the proposed amendment. The proposed amendment is provided that where multiple applications for initiation of corporate insolvency resolution process in respect of a corporate debtor are pending before adjudicating authority on the insolvency commencement date, the initiation date shall be the date on which the first such application was made before the adjudicating authority. So the initiation date, section 5 subsection 11, now it says that in case of multiple applications, the first application, like in case there are 4 applications pending against a CD, however, the first application is not adjudicated, but 4th application is adjudicated. So the date of initiation would be considered as the first application. Even if that is not adjudicated, even if the order which has been passed for commencement of CIRP is in the 4th application, but the date of initiation would be considered as when the first application was submitted, because it has an impact when we go to the transaction. In fact, the look back period will be now depending upon this initiation date, which is the date of the first application. However, in case there is an application which is filed and it is withdrawn before the initiation of CIRP, that will not be considered. If it is pending, then only that date would be considered. But it is in case it is withdrawn or in case it is rejected, then it will not be considered. It is only in case there are 4 applications, 3 applications, 2 applications pending before adjudicating authority, and out of those applications, 1 is adjudicated. How then in that case, the initiation would be considered as the first application which was submitted to NCLT. That would be the date of initiation. Going forward, we actually go to section 526, where the some words are substituted in the explanation. The existing section 526 says that the resolution plan is a plan proposed by the resolution applicant for insolvency resolution of corporate debtor as a going concern in accordance with part 2. Explanation says that for removal of doubt, it is hereby clarified that the resolution plan may include provisions for the restructuring of the CD, including by way of merger, amalgamation, and demerger. Now this word merger, amalgamation, and demerger is now changed to merger, amalgamation, demerger, and sale of one or more assets of the corporate debtor. Sale of one or more assets of the corporate debtor, that can also be added in the resolution plan. The resolution plan can always say that I will give you this much money, say 200, I will give you 200, and will also propose in the resolution plan that there are some non-core assets. Once the resolution plan is approved, I will sell those assets, and by selling those assets, I will also make this payment. That is also possible now, because see, the merger, amalgamation, demerger, and sale of one or more assets of the corporate debtor is permitted as per the resolution plan, not during the CIRP period. It is only permitted after the resolution plan is approved, and the committee of creditors have also allowed sale of one or more assets and then make the payment, or make the payment before and sell those assets later. That, of course, will depend upon the commercial wisdom of committee of creditors. So this would actually have that kind of value maximization, that in some cases, some assets are in fact non-core but having good value. So those assets can be sold as a part of the resolution plan. So when we see this, the permissible structuring method to include one or more assets beyond merger, that actually is very good. And now we also would like to see the section 528. Section 528, and there are words which are added, and I would say the proposed amendment is regarding the voting share. Voting share, because see, this is only a confusion. It only clarifies that the voting share is computed only among eligible financial creditor, excluding related parties under section 21 subsection 2. Anyone who is a related party under section 21 subsection 2 would not be a voter. They would not have a voting power. However, earlier it was to the members, and therefore there was a confusion that their voting power will also be used. So this prevents dilution of voting power and safeguards COC. Now the word which has been added, I can read this 528, states that the voting share means the share of voting rights in a single financial creditor. Shares of a voting right of a single financial creditor in the committee of creditors, which is based on the proportion of financial debt owed to such financial creditor in relation to the financial debt owed by the corporate debtor to the members of the committee of creditors who are eligible to vote. So that is the clarity. And members of the committee of creditors only who are eligible to vote. Anyone who is not eligible to vote, like related parties, will not be voting. Now coming to section 7 subsection 4, which actually has been omitted, and the section was, it says the adjudicating authority shall within 14 days of the receipt of the application ascertain the existence of default from the records of an information utility or on the basis of other evidence furnished by the financial creditor. Now, section 7 subsection 4 is omitted. That means 14 days timeline and default ascertainment are proposed to be integrated into the substituted section 7.5. So when they have omitted 7.4, they have added that in 7.5, 7 subsection 5, and in 7 subsection 5, earlier section and now the proposed section. It is only a consolidation, and also in a single step. The code will say that the provided that the adjudicating authority shall, before rejecting the application, that's a separate issue, but then we are saying the adjudicating authority within 14 days of the receipt of the application under subsection 2 by an order, admit the application. So that word may, which was there, the word may, we can see this word on the screen, the word may actually is now removed. And this word may was used in this judgment, which was Vidarbha judgment. Vidarbha in fact used this may to the favor of the corporate debtor, but now this word may has been removed. So not saying the the adjudicating authority shall by an order admit the application if it is satisfied that a default has occurred and the application under subsection 2 is complete, and there is no disciplinary proceedings pending against the proposed resolution professional. So these are the one that the adjudicating will see the default has occurred. Second, the application is complete and the proposed RP is compliant. Only three things, nothing else. The adjudicating authority will have to see nothing else. And in case it is all there, then the adjudicating authority shall admit. And if it is not there, then reject the application if it is satisfied that the default has not occurred, or the application under subsection 2 is incomplete, or disciplinary proceeding is pending against the proposed RP. Then there is a provision, there is a proviso. That proviso says that the adjudicating authority shall, before rejecting the application under clause B of this subsection, give a notice to the applicant to rectify the defects in his application within 7 days from the date of receipt of such notice from the adjudicating authority, provided that adjudicating authority has not passed an order under subsection within 14 days from the date of the receipt of the application. It shall record the reasons for such delay in writing. This clause was earlier there, and it all depends how much time the adjudicating authority has, so that they are able to pass this order within 14 days. But what is more important, what is important is that in case the adjudicating authority finds default and completeness and compliant RP, then the adjudicating authority shall admit. And in case it has any kind of, out of the three, if there is any defect, like the RP is not compliant, so the applicant will have to correct the error within 7 days. If the application is not complete, the applicant will have to correct within 7 days. And if there is no default, then the applicant will say, if there is an error in application, we will have to submit some additional documents. And that's what it is more of administrative, and it is not something that they actually have to adjudicate. The only thing is the default. So the maximum dispute can be on default. The maximum dispute can be on some document, the completeness. So these are the maximum disputes which is possible. And in fact, this is important that we have seen that the defaults can be seen. Now, the explanation 1 says that for the purpose of this subsection, it is hereby clarified that the requirement under clause A have been complied with. No other ground shall be considered to reject an application filed under this section. Now, what are the other grounds? We will come to that. Then for removal of doubts, it is hereby clarified that where a record of default in respect of the financial debt owed to a financial institution recorded with the information utility has been furnished along with the application filed by the financial institution under this section, such a record shall be considered sufficient for the adjudicating authority to ascertain the existence of default under this section. So basically, this particular, the deletion of word may and making it shall, this now overrules the judgment of Vidarbha Industries Power Limited versus Axis Bank Limited. This judgment came in 2022 by making an admission mandatory, restoring the original intent of the creditors-driven process. In fact, the apex court held that the use of word may conferred discretionary power on the adjudicating authority to admit an insolvency application, even if default was established, prompting legislative clarification. This is what is the clarification which in fact prompted. Now this admission process is a mechanistic admission process, like it is going to be, and timely decision making is also assured. Now let us see the Vidarbha Industries Power, that the judgment interpreted may in section 7 subsection 5 as clause A in the IBC as granting the adjudicating authority discretion to reject an application even if debt and default are established, such as, like in that particular case, when this corporate debtor is a viable going concern with pending claims of 1,730 crore claim before the Maharashtra Electricity Regulatory Commission that exceeded the debt amount. The court rendered it solvent, emphasizing that the IBC objective is not to penalize temporary defaulting but solvent entities. Now, in this, see, like by using this Vidarbha Industries Power Limited, there are other judgments also. Like Bank of Maharashtra, in the case of Bank of Maharashtra, Ankita, am I audible? Because there is a light failure here. Maybe the
Very much audible.
And in case I'm not audible, please call me so that I can shift to my phone.
Yeah, perfectly okay.
So in the case of Bank of Maharashtra versus New Tech Promoters and Development Private Limited, it was an NCLT. NCLAT, in fact, used this home buyer's judgment, and application was rejected because initiating CIRP would harm home buyers' interest in an ongoing housing project, prioritizing third-party rights over the immediate admission despite fulfilled Section 11. Further, in the case of State Bank of India versus Krishi Dan Seeds Private Limited, NCLT Indore, after using this judgment of Vidarbha, they in fact said admission was kept in abeyance for 6 months due to the debtor's strong financial indicators, including 175 crore in revenue, recent payment to other creditors, like 2 crore was paid to one creditor, 6 crore was paid to other creditor, and employment of thousands, warranting discretion to avoid disrupting a functional entity. These are the various reasons where the courts have started using Vidarbha. So therefore, it was important to plug this. Like there are various other things, like in the case of Ashok Kumar Tyagi versus UCO Bank, the NCLAT stayed admission for 60 days to allow evaluation of the debtor's one-time settlement counter proposal, balancing creditors' right and potential resolution process. In the case of White Stock Holding Limited versus Prajay Holding Private Limited, it was again Hyderabad NCLT, again using this Vidarbha, set aside, the parties were directed to mediation. Parties were directed to mediation due to a pre-existing disputes under the Companies Act, as CIRP would impose a moratorium halting settlement provisions. Then in Sushil Ansal versus Ashok Tripathi, NCLT Allahabad said it reinforced the Vidarbha interpretations. Applications have been rejected if filled collusively or with ulterior motive unrelated to resolution, such as personal vendettas, even with established defaults, as the IBC is not a recovery tool. However, despite the M. Suresh Kumar Reddy versus Canara Bank, Supreme Court in fact clarified that such discretion, which was used in Vidarbha, is exceptional, with admission as the norm unless the debt is not due and payable. But still, this particular clarification came in 2023, but now the lawmakers thought that this word may, it was misused, and therefore now it is converted into shall. So Ankit, this was a very, in fact, great kind of a thought, that all these litigation where the people have started arguing that this Vidarbha is applicable to our case. It is not a case of insolvency. We are solvent. There are third-party interests, and there is a collusion, or the company is doing very well, or
there's
there
only
are
a timing gap. There's
Yes.
only a timing gap. We have the money. We are not
Yes,
able to
yes,
pay
yes.
right now. It will come when the arbitration goes through. So all those things are also there.
Yeah.
So I think this is a good plug for that. Hopefully, this will be accepted by the tribunal, NCLT, NCLAT, and of course, be kind of implemented by the Honorable Supreme Court with respect to limiting the discretion of tribunals to delay the process in the wake of possible settlements happening, because we see that there's this sentiment in the NCLT and NCLAT that we are doing good work by delaying IBC initiation, but providing for settlement of the outstanding amounts. So we see a lot of delay because of that intention going to NCLAT that see, we are settling, and this is not like there was no pure. They don't go on merits. They simply say that here is a settlement, and we are serious about a settlement, and they get a stay.
See, even this amendment, along with the amendment in section 12A, I think this taking a stay from NCL 80 would be completely stopped. That's what I'm thinking, because the intention is that once the CIRP starts, it should continue, and it should only be withdrawn with the consent of the committee of creditors, and that to 90%.
Yeah, that's one. And secondly, also we see that yes, the case is there. ACRP has not been initiated, but the dates are being given because the two parties somehow say that we are trying to reach a settlement. But after filing the case, they're trying to settle. So I believe that is also something that is going to change.
Yes, yes. So coming to the next amendment, which is amendment to section 9 of the IBC, the existing section 9 says the operational creditor shall, along with the application, furnish any other proof confirming that there is no payment of an unpaid operational debt by the corporate debtor or such other information as may be prescribed. Now, the proposed word, substitution of word, the operational creditor shall, along with the application, furnish any other proof confirming that there is no payment of an unpaid operational debt by the corporate debtor or any other information as may be specified. Now, as may be specified. Earlier, it was as may be prescribed. Now, let us understand what is the difference between the as may be prescribed and as may be specified. We'll come to that. So let us understand what is as may be prescribed. Now, when we see this as may be prescribed, this actually refers to rules framed or notifications issued by the central government under IBC as per section 239, which empowers the government to make rules for carrying out the provisions. Authority for such rules or notifications is with the central government through Ministry of Corporate Affairs, which prescribes these via notifications or rules. Now, therefore, the Insolvency and Bankruptcy Application to Adjudicating Authority Rules 2016 was made. Now, when we actually say that it is now, it may be specified. No, definition says that it typically refers to regulations, guidelines, or the forms issued by the IBPI under section 240 of the IBC, which empowers the IBPI to make regulations consistent with the code and rules. Now, the authority, the IBPI, as a regulatory body, specifies these details through regulations, circulars, issuing forms. That is what is the difference. So, the basic change is that as may be, rather than going to the central government again and again, IBPI will now, based on the feedback, IBPI will prescribe what kind of documents, what kind of information is required by the applicant under section 9 to be provided to adjudicating authority. That is what is the meaning of amendment, Ankit. That is what is the meaning of this amendment. Now, then coming to section 9, subsection 5, and the adjudicating authority is mandated to pass an order within, say, 14 days of receiving an application from an operational creditor. Now, the proposed amendment says the provided that if the adjudicating authority has not passed an order under this subsection within a period of 14 days from the date of receipt of the application, it shall record reasons for such in writing. So that this clause, like it was earlier there in section 7, but now it is now added in section 9 also. But it all depends with how the NCLT is busy, how the adjudicating authority would spare time. So that's what it is. This amendment will all depend upon the. So the flexibility of the information, like that's what I've said. Now the board will decide which information is required. That will be based on the practical difficulties and also feedback. So the efficiency of 14 days in any case is there. Coming back to section 10 of the IBC. Section 10 of the IBC, again, we have this, the information related to his books of accounts and such other documents for such period as may be specified. So this was a controversy that it was it was kind of interpreted as for such period as may be specified. It was interpreted as the power of the central government is only to provide a period. Now, this has been clarified that the other document and any other information as may be specified. So, like the earlier language actually says that for such period as may be specified and such other document for such period as may be specified. Now it is and such other document and any other information as may be specified. It's a kind of clarification, and so that there is no confusion. The intention is to get the information from the applicant, so that is now clarified. Again, the basically the section 10 subsection 3, section 10 subsection 4 amendments, it is proposed that the adjudicating authority shall, within a period of 14 days of the receipt of the application by an order, admit the application if it is complete and no disciplinary proceeding is pending against the proposed resolution professional, or reject the application, provided that the application, the adjudicating authority shall, before rejecting a give a notice for rectification of the errors. Now, basically, this amendment of omission and insertion shall within the 14 days. So in case we see the amendment, again, we actually have to see the proviso. The proviso says that provided further that if the adjudicating authority has not passed an order under this subsection within a period of 14 days from the date of receipt, it shall record the reason. So one, that there is a focus from IRP scrutiny to application completeness, consistent with the removal of the IRP nomination rights. Then one, the section 10 application, earlier the RP or IRP was proposed from the applicant. Now that right has actually been taken away from the applicant. Now the IRP will be will be proposed by the NCLT. So under section 10, no IRP can be proposed. So some of the amendments are only because of this, and some other amendments are regarding the timeline for disposal of the application, maybe accepting or rejecting, which NCLT may adhere to. So this is where is the amendment of section 10. And the amendment coming to section 11, or Ankit, can we take some questions up to this?
So I think we have a raised hand from Ranjan ji. I can ask him to speak. Yes, Ranjan ji.
Sir, am I audible, sir? Good morning,
yes,
sir.
yes,
Sir,
yes, please. Good
sir,
morning.
actually related to reconstitution and resolution plan, whether a resolution applicant can bring strategic investor and the investor can pay directly, what precautions can a RP should take?
No, I still couldn't understand the questions, Ankit. In case you
I think the question is that a strategic investor can introduce money as part of a resolution plan or not. I think that's the question.
No, resolution plan is normally coming from a strategic investors. The resolution plan is coming from a resolution applicant who is ready to take over the company. He can come with the strategic investors. He can come with the partners. That is allowed. That is already allowed.
So what precaution can a RP should take? Because if the resolution applicant will say that his strategic investor will pay directly in the process, what precaution can a RP should take? Shall the RP take
RP
29?
can definitely, I understand your question. RP will have to see that section 29A is compliant. Yes. And in case it's a case of section 32A, that also should be compliant. So these are the two things the RP must see. Even if it is an investor, the strategic investors can directly pay. Directly pay to whom? Whatever money will come, it has to come to the account of the corporate debtor, the CIRP account of the corporate debtor in the case of resolutions. So the money will come to the CIRP account of the corporate debtor. From the account of the corporate debtor, it will be distributed to the creditors.
So, sir, one is 29A, another one that it should
32A.
be
32A.
32A. Okay, sir. Another query, sir. What is the entitlement of UFC if they are not provided in resolution plan, or also that
I think
distribution?
I'll request Ranjanji if we can continue with the amendment discussions that we're talking about. I think we can limit our questions to the amendment bill.
This we can
Yeah, we can discuss this
offline.
offline. We can discuss this offline. Ravi
Okay, sir.
Chandranji has some question in case we can
Thank
take.
Good morning, sir.
Good morning.
Sir, the proposed amendment in 526 is only for non-core assets or core assets also, sir?
No, any kind of asset. I just wanted to give you a kind of use of this amendment, that in many cases there are some non-core asset, and that can be proposed. The resolution applicant can propose in the resolution plan that I will sell these assets, and that actually will be used for either payment to the creditors, or he can make the payment before. But then there is a also kind of interpretation difficulty in the over IBC, that whether the resolution applicant can sell the assets or not. So this also clarifies that resolution applicant, even before the payment or after the payment, can sell the assets. So whether he is using this proceeds of these assets for making payment to creditors or not, that will depend upon the commercial wisdom of the committee of creditors. But a resolution applicant can sell the assets. That is also clarified.
But if he sells, will it not clash with the the liquidation process itself?
No, it is not a liquidation process.
Since the COC is already approving the resolution plan, COC is believing that yes, selling the assets as part of the resolution plan will maybe give them a better or a faster result. So I think that is something that they have kind of clarified, because I think this is again to clarify some judgments which say that the resolution plan cannot strip the company of assets. So this takes care of that thought process, that no, that is also allowed. Resolution plan can be anything.
Okay, thank you. Yeah, thank you.
So I think we can just say that today's webinar we can just conclude. And again, we always say that it is our way of learning. Yes, Ankit.
Right. I think we can take up maybe a few questions that are left offline, and it's already 12:08. So
yes, we can take
those
offline
right now. And if there are some raised hands, but I think I will request them to kind of take these offline.
Sure.
Thank you, everyone. Thank you so
Thank
much.
you. Thank you very much. Thank you.